Okay, so we talked about the interrogatories, and then the request for production was the last one. So this is request for admissions. When we're talking about requests for admissions, they're very, very specific, and they're limited to just one fact and one fact only. And what you do is you add something, and it will say something along the lines of admit or deny the following, and then state a fact that on January 10th, 2017, you were the driver of a 2016 Toyota. You would state, you break down the case into its component parts. That you were traveling westbound on Main Street. That you as you approached the intersection, or as you came to the intersection of Main and Broad Street, your light was red, or that you ran a stop sign. You always want it to be in favor of you, so that if they fail to answer the admission, it's going to be deemed in your favor. In other words, it's going to be deemed admitted. That's what happens when you fail to answer admissions. They're going to automatically be deemed by operation of law. So that's one of the things that you can do with a request for admission. You can also ask them to authenticate certain things. You can have documents, and you can say, look, that the contract attached here to as Exhibit A is a true and correct contract that is the subject of this lawsuit. But remember, just one fact, because if you put more than one fact in each admission and they admit it, are they admitting to, let's say, the first fact that's in the admission or the second fact? So it becomes confusing, and it doesn't have the same force and effect. If it's limited to just one fact and they admit it, then we know they admitted to that fact and that fact alone. So you've got to be very careful when you're doing admissions. Don't overcomplicate it. Don't put something in there that says, please admit that on January 15th, 2017, that you were traveling westbound on Main Street at approximately 10:15 a.m. driving a Buick Roadmaster, traveling westbound. You just had right there. There was 4 different facts, right? The direction of travel, the time of day, the vehicle that you were using. All of those things are facts, and if they admit, then they can come back and say, well, I wasn't admitting to all of those. I was only admitting to the first fact that, yes, I was driving in that vehicle on that day. And so limit your admissions to just one fact. And you can't use admissions on people that aren't parties to the lawsuit. The idea behind it is that it's supposed to reduce the number of the points in controversy. But as a matter of course, and after practicing law for 35 years and doing discovery on both sides of the docket as both representing plaintiffs and representing defendants, that for the most part, people just simply deny admissions. Whether they could say that, that you were, alive and breathing on the date in question, and they'll probably say denied. It's just a matter of course that most people just don't take admissions seriously, and they simply deny those. So as far as simplifying lawsuits and reducing the amount in the points in controversy, and practically speaking, it doesn't. However, there are situations when admissions are very, very good, and you can get parties to say things that they might not ordinarily admit to, and it depends on how you present that kind of an argument. So the other things that they talk about, the ripple effect, I don't really see that as being an effective tool. I don't think it's probably, as far as all of the tools of discovery, I think it's probably the least effective tool, simply because individuals just tend not to take admissions seriously because they're not under oath. They used to be under oath. Here in Texas they did, and then they changed that. And when they did that, I think they have a lot less force and effect. So we talked about these things. This is the reasons why you would use a request for admission. Certain facts. Now, verifying the proper application of the law in Texas, that's going to be an objection. If you ask the plaintiff if a particular statute, that they were in compliance with statute, such and such, they're going to come back and say that they're going to object as a result, because first of all, they're not lawyers. How do they know whether or not they were in compliance with the statute? Because only a lawyer is going to give you the correct application of a particular statute. So in Texas, we don't use it for application of law. We simply use it for facts and to specifically maybe authenticate documents, and that's about it. Okay, so requests for admissions are right. They can't be ignored or they're going to be deemed admitted. The problem is that that is a situation that really has no teeth. Why? Because if you fail to answer admissions, and they're automatically, by operation of law, they're deemed admitted. You used to have to file a motion to deem facts admitted, but you don't have to do that anymore. If after the due date of those admissions, let's say where they were served by certified mail, 30 days pass, and you don't answer the request for admissions, hold on one second, sorry. And you don't answer the request for admissions, then they're deemed admitted. But you know what? You file a motion to undeem the facts, they will be undeemed, and they're no longer admissions. I mean, the courts will grant that as a matter of course. Now, it says that parties must make a reasonable effort to obtain missing information. So the reason why they put that in there is because admissions need to be complete. In other words, you should be able to take an admission by itself, read it, and then read the answer, and it makes sense without having to refer to anything else. So think of admissions as standalone discovery, that there's nothing else that has to be done with regard to admission. You just ask them to admit or deny a particular fact, and then you pick out the fact that you would like them to admit or deny. You know, that you were intoxicated on the date in question, you know, that you had, you know, or that you would, you know, had been consuming alcoholic beverages. You don't even have to say that you were intoxicated. Let's just go in there and then just kind of you know, just bring up the idea that they had been drinking. Sometimes that's enough for a jury. Oh, well, look, if they make an admission that they've been drinking, then in all likelihood they were intoxicated. It doesn't take more than just a couple of drinks for the average person, especially if you haven't eaten, for the average person to pass the legal limit scale. So then you could make those arguments that you had been consuming prescription drugs, or that you've been consuming illegal drugs, or you've been smoking marijuana, or you've been you know, that you were distracted, that you were on your cell phone. That all of those things are facts that you can ask them to admit or deny, and they must admit them or deny them. And so the idea behind that is, again, it's supposed to limit the amount, not the amount of controversy, the controversies in the case. Now, you can make those requests anytime during the case in state court. You can file as many admissions as you want. I'll never forget, I represented this bar. I represented a homeowners association against a bar next to it that was making this excessive noise, and these two guys got into battles, and they were throwing eggs down on the bar from the 4th-story garage, which was right next door, and they turned on a sprinkler and did all this stuff to them, and then the bar retaliated, and it got really nasty. And I had these two of these clients. They're very, very intelligent guys, and both of them, you know, made a lot of money in the internet market, and both of them lived there, and neither one of them had day jobs that they had to do anything. So they sat around and they would prepare admissions and send them to me. And I remember one time they prepared about 300 or 400 admissions that they wanted me to send to the other side. Well, technically, you can send as many admissions as you want, but I can almost guarantee you that if it gets to be excessive and the court thinks that you're abusing the process, then the court is going to probably strike those admissions. So just be wary of that. Okay. Hold on, I lost something here. There it is. Okay. Okay. Request for admissions. Drafting the request. Most of the time, the supervising attorney is probably going to come to you and he's going to say, look, here's our facts. We've got this automobile accident. You know, we represent the plaintiff and we're suing the defendant, and we don't know what was going on. We don't know where this defendant was prior to the accident in question, but maybe it was at a bar, maybe he was at a house party drinking. Let's get some admissions in there that he'd been consuming alcohol. Let's get some admissions in there that he'd been consuming illegal drugs. Let's get some admissions in there that he was taking prescription drugs. Let's get some admissions in there that he was in an impaired state at the time of the accident. Let's get some so those are all kinds of things that could be beneficial for you in the event that you can get them to admit, or if they fail to admit, they can then be deemed admitted. So that's what you're doing. And you're not going to get a whole lot out of the pleadings in an answer, because naturally the only thing they have to do is a general denial. But if you've been conducting discovery, and there's some documents out there, there's photographs of the scene of the accident, you can ask admissions about all kinds of things that would be relating to the prosecution of your claim. Or if you're on the other side, then you can ask admissions about, well, you were injured prior to this accident happening, that the very injury that you're complaining about is an injury that pre-existed this accident, that you're exaggerating all of those kinds of things are admissions that the defendant could then send to the plaintiff. So there's all kinds of things that can be done, and I generally would give the fact situation to my paralegal, and I'd say draft a set of admissions. They would draft admissions, and probably a majority of them would be good, and then some of them would not be any good, and then I'd strike those out, and then we would work from there. And so the whole idea behind it was that we want to make sure that we're getting as much information, getting the most bang for our buck, because admissions are inexpensive. They're just discovery that's served, and you spend a couple hours performing it, and then you serve it, and then they have to respond to it. So it's drafted. It's just the same as what we did with all the other discovery, like with interrogatories and requests for production. The admissions are the same way, same exact format, cause number at the top of the page, court designation to the right, plaintiff defendant designation to the left, and the center of the page would be the caption identifying who's sending it. And I always like to put in there plaintiff's request for admissions, and then it'll say to, and it'll say defendant by and through as attorney of record, whoever the attorney of record is, and it says, plaintiff hereby serves upon you the following request for admissions to be responded to on or before the expiration of 30 days from date of receipt, and then you have your signature, and then you have a certificate of service, and that's it. You don't have to have definitions and instructions with admissions, only because the admissions should be so clear and so self-explanatory that a definition or instruction is not needed. So, and so what you can do when you get the admissions, let's say that you're on the receiving end of the admissions, right? Let's say that you represent the defendant and the plaintiff has served these admissions. Well, then the thing that you're going to do is there are options. You can admit that it is correct. You can deny that fact that's being submitted, the admission is correct. You can't refuse to admit or deny it. You have to admit or deny it, but what you can do is say that a plaintiff cannot admit or deny because of insufficient facts. Okay, if you don't have enough facts in that admission in order for you to be able to form an opinion as to whether or not you can admit or deny, then you can state that you cannot admit or deny. But you can't just, at least in Texas jurisdiction, you can't refuse to admit or deny. You've got to do one or the other. Or you state that you're without sufficient information upon which you can admit or deny, or you can admit in part and you can deny in part, but that's where you get to the point where admissions need to be very clear in only one point, because then you take that one away. Because if it's only one fact, it's either admitted, it's denied, or you're going to say that you're without sufficient information upon which that you can admit or deny. And then you can also file objections. But just the mere fact that you file an objection doesn't give you the right not to admit or deny it. For instance, unless, of course, there's something, it's of a privileged nature, or it's attorney work product, or whatever it is, that would be something where you just you would just say, plaintiff objects to this admission as it invades the attorney work product privilege, or the plaintiff objects to this admission as it invades the attorney-client privilege. So those objections are legitimate, but a lot of times people will object because something is compound. Something is compound if in one that it seeks two answers in one question, or that it asks two questions in one admission, or seeks two facts in one admission. In other words, if it's not, that's why I'm telling you, and I know I'm being redundant about this, but I want you to understand that each admission is one fact and one fact only, because that will eliminate that objection if you do it that way. Okay, so these are some of the objections, and there it is. You can see the attorney-client. They said medical privilege, inadmissible and irrelevant. That is not an objection. In Texas courts, you cannot object that something is inadmissible or that it's irrelevant. The court is going to turn around and they're going to order you to do that, or else they're going to deem it admitted, because you don't make that determination. The judge decides what's relevant and the judge decides what's inadmissible. Now, you can make the objection, said, plaintiff objects to this admission as being irrelevant and inadmissible. And then then you would put something subject to the objection, plaintiff denies. Okay, so you put your objection in there, but you still have to respond to it. And now, if an admission is improperly worded or poorly worded, then you could make an objection like the next one where it says overbroad, or if it's duplicative where it's been asked before, then you can put those objections. And compound, that's the one where you have more than one fact in one admission, which again, I'm telling you, make sure that they're one fact and one fact only to each admission. Okay, so we're talking about, and this is not in Texas, this Discovery Protocols pilot project. Maybe in the jurisdiction for the people that wrote this book, there might be something like that. But in Texas courts, we don't have that. And again, I don't know that it exists in the U.S. District Court for the Southern District of Texas, because I have not practiced in federal court in 10 or 15 years. So this may be, but it says that in the federal courts, it's designed to streamline the process in employment cases. So that may be the case too, because I never handle employment cases. That's not an area of law that I practice. So whether or not this Discovery Protocols pilot project, whether it's there or not, I don't know. It says it's a volunteer program and it's currently underway in 8 districts. So I don't know whether or not the U.S. District Court for the Southern District of Texas is one that participates in that particular program. So I can't really tell you anything more about it than that, because I'm not going to lie to you. I just don't know any more about it. Okay, so ethical responsibilities. Yes, you do have a responsibility to keep abreast of the newest developments in the electronic storage of information, the ESI. So the idea behind that is because technology continues to change and to evolve and to morph into different things. And 5 years ago, I don't think we had clouds, and now we have cloud storage. So there's all kinds of things that are going on. And the idea behind it is you as a paralegal need to understand what's going on. You should be going to seminars about electronic discovery, about electronic storage, about all of these kinds of things. And the more you go to these things, first of all, it's good to have that on your resume. If you leave that firm and you go to another firm and they see that you've been to all these seminars regarding this, they're going to feel that you probably have a pretty good handle on it, and that may be a selling feature in and of itself. So I always recommend to all the paralegals that when you go to a law firm, you look at seminars that are coming up that are being offered in your area, and ask the firm, say, look, there's a seminar on electronic discovery that I would like to go to. They'll send you to the seminar. They'll pay you to go to the seminar. They'll pay for the seminar. The only thing you have to do is bring your lunch, or sometimes even they provide you lunch at these things. So go to all of these seminars that you can go to. Good law firms love for paralegals to constantly be learning about new developments in particular areas, especially when it comes to discovery. And finally, the idea behind discovery rules, and it's not just in federal courts, it's in state courts as well. They're always changing. When they see a particular area, and there's so many cases that are coming around that are evolving as a result of a particular rule, they go in and they want to change those rules because it's causing a lot of things. It's something that was unforeseen. So the point of all of this stuff is that there is a constant evolvement of discovery, especially when it comes to electronic storage of information. And with regards to that, you've got to be prepared to understand what it is. Now, I was talking last session about spoliation. I've been involved in a couple of cases where there was arguments about spoliation, and in one of the cases there were some documents that were destroyed, and in another situation there was some tangible evidence that that they knew they had, which would have proved one way or the other the existence of something, and they had it destroyed. And so in those arguments, you can argue that whether it was accidental or deliberate, but that it was still spoliation. Okay. All right. So that's our assignment with regards to this particular chapter is going to be to prepare a set of requests for admissions. I'll put the facts out. I'll send it to Eric, and he will post it for you, and that will be available. Jesus Christ. And that will be posted, and then that will be your assignment to do. So, okay, so that is the first half of our class. I'm going to take a 2-minute break, but you guys, for you, it'll seem like just seconds because I'll be right back.